Well, in a 6-3 opinion, the Supreme Court ruled today that former presidents have absolute immunity from prosecution for official acts. We'll get to what that means in a little bit here, related to their core constitutional powers.
But the court said there is no immunity for unofficial acts and gave some guidance on how lower courts can draw that line. To talk more about this, right now we are joined by Chris Pannozzo, a local attorney and a legal analyst. Chris, it is great to have you here. Thanks for coming in. If you can, for those who may be a little unfamiliar with this ruling, what exactly is happening? What does it mean?
So what the Supreme Court found is that a president has absolute immunity for what are called official acts, or certain acts that only the president can do. They noted that there's no immunity for what we call unofficial acts, so there's no immunity for that. But then there's this kind of middle part, which is could be official act, could be a not official act, and that's where a lot of the issues are going to be here.
Yeah, so we have kind of three buckets, right? And we don't exactly know what each bucket is.
That's correct. So the appeals court, the Supreme Court, did not give any real guidance as to what that is, other than, in this case, former President Trump talking to Attorney General Barr or the Attorney General's office. They're saying because he only can deal with the Attorney General's office, he's absolutely immune from that. But other than that, this is going to go back to the trial court.
When it comes to making the decision, what are some of the things the Supreme Court could have maybe looked at to come to this ruling?
Well, they're saying that they were looking at historical precedent, but there's really no precedent to this. There's a lot of dispute over what the original intent of presidential immunity or absolute immunity was. So we're really in uncharted territory here.
Okay, and how does this impact Trump? And how does this impact some of his trials? It pushes those down the line. So
what's going to happen is the trial court's going to have to determine what are considered official acts and unofficial acts. That will entail hearings, and in federal court, nothing happens fast. So this will push the case likely well past the election.
And Trump himself is calling this a big win. Would you say, that this affects maybe his other cases as well? Does anything about this ruling?
I would say that it's a narrow ruling. It's definitely a win, but I would not say it's the knockout punch that he was looking for.
What is a timeline we're looking at now for the lower courts to decide on all of this? I mean, this is just so open-ended, it feels like.
Yes, court cases, especially federal court cases, do oftentimes take a while. What likely is going to happen is the trial court judge, Judge Chutkan, in the district court will probably ask for some briefing on this and oral argument and things like that and write a decision. So I'm guessing probably another 4 or 5 months before you really have anything moving forward to trial.
Wow. And to go back to what you were saying before, I think Trump himself was hoping that this indictment was going to be dismissed altogether, right? What were some of the things that he was looking for? He
was looking to dismiss the indictment completely and threw out a number of really, I would say, pretty frivolous arguments relating to that, at least very novel arguments. Those were rejected by the Supreme Court here. While I do think that this decision is pretty far out there, it's not as far out there as what the arguments of the former president were.
Okay, got it. Let's talk about Chevron a little bit.
Sure.
Tell us what you know about that.
So the Chevron, for years back in 1984, there was a decision called the Chevron case, and what basically it is, and it's kind of a complex thing, but essentially when there's a law that's passed, the executive branch then makes rules to implement those laws. What the Supreme Court before this weekend found is that the executive branch or the agencies are entitled to deference. They've removed that, and that's about 40 years of preference that have been removed in this situation. So what they're saying now is that those are things that are to be decided by the district courts themselves, which will bring a lot of extra litigation going forward on regulation.
How big of a deal is that for climate policy? I mean, you're talking about 40 years, that's a long time.
Yeah, it's a very big deal, not only for climate policy, workplace safety, other things like that. What it will do, it will allow for people who are disagreeing with certain amounts of regulation a lot more leeway in the courts. And you'll probably see, because every court's different, every judge is different, you're going to see a lot of different decisions. And at some point over the next probably a few decades, you're going to see it kind of take shape. But it's going to be quite a mess for a while.
Okay. Chris Pannozzo, thank you so much for joining
Thanks
us,
so much.
legal expert. We really appreciate you always coming in.